If you're building your ABA company and you're tired of guessing, this is for you. We built the EBCBA blueprint to give you real structure, systems, and support without the fluff. Details are in the description. Welcome, everyone. I want to introduce you to my friend Sam. Sam and I met some time ago, and when I found out that Sam was both a lawyer and very connected with the ABA business, and that was his focus, I said, I got to meet with him. So we sat down and had a conversation. And one of the first things that I asked Sam was, what do you charge to form an entity like an LLC or an S Corp for an ABA company? And Sam's answer was perfect. He said, we usually don't do that unless we're doing something else for the client, because really that's something that you can do yourself. So in an industry where it's common for BCBAs who are starting up, you're looking for advice. This happened to one of our clients. They called one of the accreditation entities and said, I'm starting a business. What do I do? That organization sent them to a lawyer. That lawyer charged them $3,500 to do something that you can do yourself for $150 in pretty much whatever state that you're in. I don't know of any state that you can't go and file online. And this is the kind of wasted resources that we see in the ABA startups that is heartbreaking, because that money could be used to do something valuable for that business. And that's what our program is all about, is helping you get around those things, navigate the rocky waters. And there's a lot of misconceptions as well. And this is what Sam's going to talk about today. But I even deal with lawyers sometimes of clients who are telling the client something that is not accurate when it comes to the compliance side. And it's difficult for me to communicate with the lawyer, because who am I to teach them anything about the law? On the compliance side, this is what we're in and day out. This is what we know. And when we're dealing with a breach or some kind of a compliance audit, there's not much overlap between the legal industry and compliance unless someone is specialized. Going from general law to HIPAA compliance is a big jump. Two different types of practices. Going from HIPAA compliance to pediatric HIPAA compliance is another smaller jump, but a jump nonetheless. The final jump that Sam has made and is focused on is specifically the ABA market. We are blessed to have him on the ABA Impact team, and he's so willing to share his time with us and his knowledge. And that combination of things is the reason that I call Sam the unicorn. It's very difficult to find somebody like Sam, and I thought for a long time it was impossible. So please, everyone, welcome Samuel Bryant. Sam, thank you for sharing your time with us today. Take it away, sir.
Thank you, Derek. I really appreciate that introduction. One thing I wanted to say for you all with the ABA business is there is a personal connection for me. My nephew has autism, so I think that what you all do, the service that you provide for our society, it's still sorely needed. And I appreciate that as a professional, because on a personal level, I see that impact directly. My nephew's 9 years old now, and he works with a therapist. So I just want to thank you all, because the work that you do really does make an impact. I want to share with you all first the inspiration behind this presentation. I was speaking with Derek and Josh about what I do, and we just got to a conversation about how can I, as an attorney, add value to your community. And Josh mentioned that there's a huge misconception about how BAAs are used in the industry. And we got the sense that a lot of the ABA owners believe that when I integrate or use Google or these software programs and they're giving me these BAAs and I sign them, I'm HIPAA compliant. And that's a huge misnomer. It's a huge myth. Even when these software companies are selling you upgrades of HIPAA compliant versions of their software, that does not mean that you're HIPAA compliant by signing a BAA. So we're going to be digging into that with this presentation, and it's going to fit in the overall context of HIPAA compliance. So before we begin, just a little bit about me. I have been practicing business law for about 10 years now. I've had my own firm for about 7 years. All of my clients are business owners. My role is to provide liability protection for our clients. So we've to date served over 400 businesses. To our core, yes, we draft, review, renegotiate contracts, and we serve as outsourced general counsel. But I believe that my value is and actually understanding the business model that you all have, and then identifying the risks in executing that business model from a legal perspective. My role is to understand that business model and then educate you on those risks that your business model imposes on you so that we can make sure that you have liability protection. I am a Florida bar attorney. HIPAA is going to apply to all of you because you're healthcare providers, but there's a layer of state regulations on top of that. So I'm going to stick to the federal regulations that apply to all of you. But just so you know that the little details that I have are from my experience as a Florida bar attorney. So with our agenda, we're going to really start off with what is HIPAA compliance and why it really matters. Why does it matter that you're sitting here? Whatever you end up learning and taking away from this is meant to educate you. It's up to you to do what you want with the information, but we really want to explain to you why this is important. The financial risks involved in not complying with HIPAA are significant. And I don't know if you all appreciate that or at least even know about it. So we're going to go into those specific financial risks so you understand why this is all important. Then we're going to transition to the roles of the BAAs. You all are using technology in your companies, and we want to make sure that you're using the BAAs correctly. There's a way to use it internally between you and your team, and then there is a way to use BAAs externally when you're engaging with these third-party vendors. Then we're going to really go into the software mess. This is the inspiration for this presentation. We want to really dig into what's being said out there and what's really the truth. And we're going to wrap up the conversation with a compliance roadmap. I want you to walk away with actionable steps that you can take to really ensure that you're being HIPAA compliant. So HIPAA compliance really matters, in my opinion, for 3 reasons. It protects the privacy of your patients. You're dealing with oftentimes children, and you really want to make sure that information is protected. And as an ABA business, you're dealing with a lot of different relationships. You may be dealing with schools, you may be dealing with parents, and you're dealing with the kids themselves and insurance carriers. That information that's being shared between all these different parties is very sensitive. And so this is why HIPAA compliance is so important for you all, just because by the nature of your business, especially because it's a data-driven business, the analytics that you have require this retention. It requires you to store this information. You really want to make sure that you're doing it correctly. I just want to actually also point out that I've heard this before, that there are some business owners that think that, yes, I may have an ABA practice, but I don't bill insurance, so I don't need to worry about HIPAA compliance. And that's actually not true. You are all considered covered entities under HIPAA, regardless if you bill insurance. So this is why it's a legal requirement. But also, practically, you build trust with your clients and your partners. Again, as a parent, right, their children and the help that you're doing for their children is of the utmost importance to them. If that data gets compromised in any way, it's going to affect them in a very special way, which means that the consequences to you are going to be even more impactful. If I was selling a candy bar and I was collecting some information from my customers, their names and just the email addresses and phone numbers, if my data gets hacked and the extent of that is just the emails and their phone numbers, it's not good. But the impact is not as much as you all. Someone breaches your systems. If your client's information gets breached, that's sensitive information that is out there. And so you want to build that trust with this HIPAA compliance. You want to be able to speak with integrity when you are trying to when you are trying to onboard your patients, when you are working with the schools, when you are working with the insurance companies. And also, if any of you have any interest in selling your practice one day, this is what the potential buyers will be looking at. They're going to be looking internally to see how compliant is this company, what exposure do I have as a potential buyer of this potential practice, and if I acquire it. So for all these reasons, you really want to take this seriously. What I want to do now is going to transition to consequences of non-compliance. We are all in business to make money. You can't make money if you're losing it. So what you may or may not know is the consequences for violating HIPAA can be very severe. And the most important thing to understand is it doesn't matter if you didn't know. It doesn't matter if you tried your hardest to comply. The fact is, if you violate HIPAA, if there's a breach, you can be penalized. So I created this table to help you understand how the government and how these regulators categorize these offenses. So they do them in tiers. So tier one, unknowing, really means that I just didn't know a violation occurred. So a good example is you use maybe a payment processor and that processor gets hacked and you didn't know about what happened on their end. However, if you're exchanging PHI with them, that is a HIPAA violation. And so at a tier one level, it doesn't matter if you knew or didn't know, you can get penalized. The way this works is you get penalized per violation, and it can range from $100 to $50,000. If you're asking, you may be asking yourself if the annual cap is $25,000, meaning you won't be penalized any more than $25,000. The way this works is if any one breach can cost you up to $50,000, but if you have a continuous breach, so it's the same breach that occurs multiple times in a given year, you can only get charged one time under that cap. Tier two, reasonable cause, means you should have known, but you didn't act recklessly. So let's say that you have an RBT that sends session notes to a parent, but they mistakenly include notes meant for another child because they just copy pasted information wrong. So this is considered tier two violation. Tier three, you are aware of the non-compliance, but you didn't act until after the violation occurred. And the main difference between tier three and tier four is in tier four, you are aware of the non-compliance, but you failed to act. So as you can see, depending on the tier, the violations get more and more steep. What I want you to take away from this is the real differences between tier one, tier two, tier three, and tier four is in tier one and tier two, if you have protocols in place and you have done the work internally to develop processes and you're working with the right people and you're doing your assessments on a periodic basis, your violations usually will stop at tier two. If you don't have any protocols in place and you suffer a violation, you could get locked into tier three and tier four territory. And as starting out, the worst thing that could happen to an ABA practice when you first start out is that you get one of these huge HIPAA violations and your business gets tanked before it gets started. So you might be asking yourself, I understand that's the consequences, but what, does that actually really happen? Do businesses really get penalized? The answer is yes, because there's a obligation under HIPAA for you to report violations. So as a business, if you are violating HIPAA and you know it, you actually have a window of time to report that. And then it gets determined what the level of violation will be. There are instances where you won't get a monetary violation. You may just get some guidance, but that doesn't mean that will always be the case. And so I wanted to provide some real world examples of businesses that got fined real money for these HIPAA violations. So there was a business, it was a dental practice that hired a security company to destroy physical records of their patients, patient records. And that company did destroy some of those records, and they put the rest of the records in a dumpster. And that dumpster happened to be located next to a church, and someone saw it and reported that company or that dental practice. So they got fined $10,000. Another company was a medical transport company, had a encrypted laptop in the back of one of their cars or ambulances, and hit a speed bump. That laptop actually fell out of the truck, and they didn't realize it. Someone picked up that laptop, found PHI on it, and reported them. $60,000 fine. So last fine, a owner of a medical practice took their laptop home, and a family member took that laptop and downloaded inadvertently some malicious software onto that laptop. That laptop had PHI on it, and the OCR, this is the Office of Civil Rights. This is the organization that actually implements the discipline for HIPAA violations. They fined that company $150,000 because at least they concluded that owner failed to install the proper firewall and safety and security updates on their laptop. So when I look at HIPAA compliance, I think of it as a three-pillar structure. There's the privacy rule. This governs who can access private health information and how. The security rule is the safeguards for actually protecting your digital private health information. And this is what you all are doing internally within your own organization. What protocols, what procedures do you have in place for how private health information is being implemented? And this is what I was alluding to earlier. This security rule, this is what the adherence to the security rule is really what helps cap and limit your potential consequences for violations. And the breach notification rule. So this is what happens when data is compromised. Like I said, if there is a HIPAA violation and you're aware of it, you actually have an obligation and a window of time to notify that the breach has actually occurred. So I want to transition to the inspiration of this particular webinar, which is the Business Associate Agreement, or the BAA. The BAA, to its core, is a contract. It's a contract between a covered entity and a business associate. What is important to understand is, when are you considered a covered entity and when are you considered a business associate? So when you're signing up for the Google Workspace and they're giving you a BAA and you're signing that BAA, you are actually naturally a covered entity, but in the context of their BAA, you are considered the business associate. So it's very important to understand the parties and their roles in the actual contracts. These agreements ensure that the vendors or third party will protect PHI. So in the context of a Google Workspace BAA, you are considered the third party. And so they are telling you in the contract that you are protecting the private health information that's being shared between yourself and their platform. What I don't hear a lot from ABA companies when I first work with them is, what are they internally giving to other third parties or other vendors when they're engaging with them and sharing private health information? The most common scenario is, you may be starting out and you don't hire a W-2 employee. You may want to hire a 1099 contractor. If you're hiring 1099 contractors, you should be giving them BAA agreements to sign, because in this context, if they're not a W-2 employee, they're not under your umbrella. They are a separate entity. Even though they're an individual in the eyes of the law, they are a separate entity. So you need an agreement between yourself and those 1099s. The main point that we want to drive home in this webinar is, software itself does not make you compliant. So when you are engaging with these companies and they are, whether it's an advertising or a marketing effort or even on a sales call, and they say, we have HIPAA compliant software, that is, I don't want to go as far as saying it's a lie. I will say that it's extremely misleading. It was one of the companies, I think it was either Google or Microsoft, actually has in their language that is a disclaimer that the Department of Health and Human Services does not certify, recommend, or in any way endorse any software. So in other words, just because you're using a software, it does not in and of itself mean you're being HIPAA compliant. And I read through a couple of the BAA agreements through Google, Microsoft, and some other companies. And I was just curious to see what are they actually telling you and how far are they going in their terms. And in Microsoft specifically tells you that you are responsible for implementing security and privacy safeguards. So there is, in their own contracts, they are putting obligations on you, because in this context, even though that you're sharing your private health information, or at least your patient's private health information, they are making you obligate yourself to being HIPAA compliant. They themselves may have their own protocols for how they're being compliant on their side, but they're protecting themselves. They are not protecting you with these agreements. So this is that myth that we're talking about. I want you to walk away from this conversation just being aware of what's being told to you, especially because in your industry, there are marketers, software companies, vendors that you're subject to these rules. And they know that for those of you who really care about compliance, you might be willing to pay a little bit extra. So I'm not saying do not buy these services. What I'm saying is don't think that buying these services means that you've done everything that you have to do to be HIPAA compliant. I actually spoke with a marketer, I think it was actually earlier this week. And she told me she was working with a CRM and she described that CRM as HIPAA compliant. So I know that this is going on. And so just be cautious of the rhetoric that's being told out there. I want you all to understand what the truth really is. And the truth is that there is no such thing as HIPAA compliant software. There's so much more to it than that. So when you are working with these vendors and you do sign the BAAs and those are in place, what do you actually have to do to become HIPAA compliant? I think the best analogy that I can think of is when you sign these BAAs, it's like getting a gym membership. Just because you have it doesn't mean you're going to lose weight. Once you get the membership, you still have to go to the gym. You still have to lift the weights. You still have to eat right in order to get the results that you're looking for. So when you have the BAA in place, that's just really the first step. There's things that you got to do after you sign the BAA to make sure that you actually are HIPAA compliant. So we'll discuss some of that. So once you engage with this new vendor and you've got the BAA in place and you're starting to get onboarded, really the first thing you should start doing is you should be conducting a HIPAA risk assessment. I don't care if let's just say that if you signed an agreement today, and I don't care if you did your last assessment a month ago. There is no hard, fast rule on how many assessments you have to conduct in a given year. The framework I like to use is whenever the technology that your company uses, when it changes, that's when you want to conduct a new risk assessment because you're now adding a new way that PHI is being shared within your business. Conduct your HIPAA risk assessment, create policies and procedures around how PHI is going to be shared with you when using that software. So if you sign up for a Google Workspace platform and you are utilizing Google Drive, for example, you need internal policies on what information goes into the Google Drive, who has access to the Google Drive, and how that information gets shared. But these policies and procedures are just words on paper. It's a great next step, but you actually need to train your staff on your policies and your procedures and how to be using the technology. Because again, you want to be establishing a foundation to where if there actually is a violation, you can point to your personal policies, your procedures. You can point to how you're training your staff. Because if a fine is unavoidable, then let's never get into the tier 3, tier 4 realm. If we're going to have to get a fine, let's try to get that tier 1 fine. Or tier 1 fine means you don't know, but if you do know about it, then let's just at least get into tier 2 to really mitigate the extent of the consequences that you'll face. So after you train your staff, whatever necessary administrative and technical safeguards you need, you got to make sure you implement them. So that could be, you might need to work with IT. You might need to hire someone internally, depending on what software you're implementing or how much information is being shared. You want to just make sure that you have those in place so that you are really actually now complying with the BAA. Without these in place, you're only getting a partial picture of the compliance part. You actually may not even be in compliance with the actual BAA. Because if Google requires you to implement protocols on your side and you don't do it, then you're technically violating the contract between yourself and Google. So with this risk assessment requirement, it is mandatory. Again, there's no hard, fast rule on how many times you have to do it. You should be doing it at the very bare bottom 1 year, 2 times a year, once a year, twice a year is good. But really, it's getting that assessment every time you're integrating new technology in your company is what's going to give you that most assurance that you are being compliant. So one of the reasons why I, as an attorney, offer the outsourced general counsel services to my clients is because for the clients that really want to be compliant, compliance is not a one and done activity. There's no really check the box. Once I check the box, I'm done. It's a journey. And for an ABA practice, when you are growing and the amount of parties that you're interacting with, whether it's the schools, the insurance company, the kids, the parents, as you grow, the relationships grow as well. And the number of relationships you have, and even with even a particular patient that you have, the depth of information that you have on a particular patient starts to increase. And so there's always an ongoing obligation. And so I would just want you to understand that it's just like staying in shape. You don't, if you really want to be in shape, it's a journey. It's something that you're always working on. You're always striving towards it. It's never okay, now I've reached the destination. I don't have to worry about anything ever again. So this journey involves training. For those of you that have staff, is having that continuous training with them. Whenever you're integrating new technology, it's the protocols. It's really educating everyone on how to stay compliant. The bulk of the clients that I work with have staff. And this is where we see the biggest issues. It's not you as the business owner that's really making the mistakes. It's when you start to recruit people in your organization, it's the staff that ends up making mistakes. And it's the staff that may end up violating the policies and the procedures. And so that training is always important. Security updates, when you are working with software internally, you got to make sure that those updates are just continuous. The software, everything we're working with, it evolves so fast. You just want to make sure that you're always staying on top of that. Your reviews, your policy reviews, just because you have a policy in place doesn't mean that it's going to be relevant for you forever. You want to periodically just review that to make sure that what you have in place currently, it reflects the nature and the state of your business now. And as an attorney, I'm always going to say documentation is key. You always want to make sure that everything is documented. So let's take some actionable steps here. Let's say, okay, I heard you, like what I'm hearing. What do I actually need to be doing to be getting compliant? What are my next steps? So the first step is I have here designate a HIPAA compliance officer. What I'm not saying here is I'm not saying you need to hire someone whose job is to be a HIPAA compliance officer. What I'm really saying is you need to allocate responsibility for HIPAA compliance to someone. If you're the only person in your organization, that means that's you. You are wearing all the hats, but what I want you to be thinking about is creating this new hat. This new hat in your business is going to be who's going to be responsible for HIPAA compliance. And so whether that's you or someone else on your team, or if you are a larger organization and you can't afford to hire someone, only job is to make sure you're HIPAA compliant, then great. But just make sure that you're honoring that portion of your business that's going to help protect you. Next, when you sign a BAA with an outside company, just now be aware of what potential obligations you're going to have after you sign and implement that. That's externally. Internally, whenever you're bringing in a 1099 contractor or 1099 employee within your organization, make sure that they are signing BAAs. And let's say that you're deciding to work with a marketing company or maybe a CRM platform that records certain information. Maybe they're a smaller organization. If you're working with them, you need to be giving them a BAA if you know that PHI could potentially be shared between you and that organization. If they refuse to sign your BAA, you cannot work with them. If you know that PHI is going to be shared, you have to have these BAAs in place. Next is conduct that risk assessment. Again, there's no hard, fast rule on how many times you have to have it. My suggestion is every time the software makeup of your company changes, do the assessment. When you know that you're going to be HIPAA compliant at that given time, when you can actually successfully pass your risk assessment. So just because you do the risk assessment today and you're compliant today doesn't mean that you're going to be tomorrow, depending on what happens in your organization. Next is you draft HIPAA policies. You don't legally have to have an attorney draft policies for you. The benefit of having an attorney draft the policies is that we have the broader knowledge base and experience to know what should be included, but you may not be at the stage where you can afford an attorney yet. You can do these yourself. You can draft up policies to help at least have something in place so that everyone understands how we share information, who has access to that information, and what procedures do we have in place in dealing with that information. Again, you're training your staff regularly and you're documenting everything. I can't stress that enough. Documentation is a short-term inconvenience, but if something goes wrong, you're always glad you have it. It's almost like a seatbelt. Maybe it's restrictive when you're trying to move around in your cars. There's a little bit of an inconvenience, a little bit of annoying, something that you just do. And when things are right, things are going right, you don't ever really notice it. But if you get into a car accident, you're always glad you had the seatbelt on. So I want you to think about that. If a breach actually happens, it could be the difference between you getting fined $2,000 and getting fined $20,000. As we wrap up, the key takeaways here is ignorance is not a defense. In the tax world, there's certain tax laws that you don't have to be aware of. And if you violate it, you get a pass for the first time. In your world, unfortunately, you don't. When you have to be HIPAA compliant, when you're a healthcare provider, not knowing the rules is not an excuse. Having software does not save you. So just keep that in mind. I'm not telling you don't sign these agreements with these other companies and these other vendors. I'm just saying don't let them lure you into a false sense of security by thinking just because I have the software, I'm going to be compliant. There's so much more to being compliant than just agreeing to buy software. And even when you're using BAAs, they're just one piece of the puzzle. Think of the BAAs as it's almost a bare minimum that you have to follow. Once you have the BAAs in place, and that's when the work really starts. And that's why compliance is a process. So if I could summarize all of this presentation in about 20 seconds, if you collect, store, use, or transmit health information that's tied to an individual, and that applies to all of you in the ABA space, you have to keep it private. You've got to keep that information secure. You've got to tell your patients how you're using it. If that information gets leaked or breached somehow, you've got to report it. Sign contracts with third parties that are handling that data, and to train your team to make sure that you're staying compliant. So that's my presentation. I hope you all got some value out of this. I am involved in the Facebook group. I try to get on when I can. I'm not sure, Derek, if we have time for questions. I'm not sure how we handle that.
Absolutely. I have a bunch of questions. If you've got time, I've got time.
All right.
All right. This is beautiful. I thank you for putting all the time and energy into putting this together. The misconceptions and the blind spots is the biggest problem. And we want to just shed light on these areas for business owners. And all of this comes back to governance. Your HIPAA policies aren't a box that you want to check and say, okay, I have this policy, so I'm HIPAA compliant. That's not really what those policies are for. The policies should be doing something positive for your business and helping you make good decisions. That is your governance. That's how you run your business. That's how you micromanage without being there all day. So these are tools that you should be using as a business owner to operate a profitable, scalable business. And at the same time, make sure that you're meeting the HIPAA standards. If anybody has any questions or comments, go ahead and drop them in the chat there. I also dropped our link for just our basic contact form on our website. If you guys want to do a risk assessment, if you want Sam involved, we'll put it all together and help you get that set up. But we have a shortcut for the risk assessment. Most ABA companies are without a compliance program yet. So the Health and Human Services, I've also dropped the tool in the chat there if you want to open that link and go straight to the HHS. It's a really long process to go through all of the questions, and it's muddy water as far as the terminology goes. So what we do is when you guys are starting your compliance program, there's been this dark area that you haven't been paying any attention to or didn't realize was there. You open it up and you say, oh my goodness, cans open, worms are everywhere. What do I do now? Divide and conquer, right? You don't need to start going question by question through the HHS thing and then calling your IT guy and then calling your lawyer and saying, all right, I need to take care of this thing. If you do that, number one, it's going to take forever. Number two, it's going to be super expensive, but it needs to be done. So what we do is we have a package, and it's basically up to 20 users. It's $7,500, right, for us to come in and do a risk assessment. We do these all the time for any company anywhere. If you're in the ABA Business Challenges group, we have a special one that's designed for ABA companies because we know what questions to ask and figure out exactly what path we need to go down. And we've broken it down into 20 questions. We do a penetration test, a risk assessment on your email and productivity, Google, Microsoft, whatever you have. And then we also go through a 20 question breakdown instead of the crazy HHS thing. And it's $197. Now, I wanted to dive a little bit deeper, Sam, into what your approach is when you're doing that divide and conquer phase, when you sit down with a client. You're coming in from the legal side, we're coming from the tech side, and everybody's got to work together. And we're meeting in the middle where we've got a company who maybe doesn't have any systems in place yet. They don't have any documentation, or they have documentation that they bought on Instagram when they were starting their business and it doesn't really apply. So what is your kind of breakdown process on how you bring a client with no security, no compliance, and start moving them in the right direction?
Yeah, so it starts well with that conversation. I really want to get a sense of where the business wants to go. So there are owners that really are looking at this business as it's a lifestyle business. It's something that I'm not really looking to grow too much. I just want the income. I like the independence, and that's where I want to be. Then you've got the group that says, this is something I would really want to grow and I want to scale and one day probably sell if it comes to that. I take a different approach depending on where the goal is. With the companies that are really just looking to sustain themselves from a lifestyle standpoint, we implement a base package where just have this in place for right now. And we charge on flat fees. We don't charge hourly. From there, it's a relationship of just checking in on what's going on, what are your challenges. There are some clients who decide, I want you to have more of a pulse on my business. For those clients, we engage on the general counsel relationship. That requires the check-in calls. Because of that natural touch point that we have with them, we get to determine where they are under risk assessment. We're encouraging them to do the risk assessment. And then depending on where they are, we are adjusting what we're doing for them. We're drafting the contracts that we want for them. We're reviewing the policies. If they're telling us they're going to be hiring people, with who are you going to be hiring for what position? So the nature of the relationship starts to evolve. When you have the companies that are just outright saying, I want to grow and I want to one day sell, then we go straight into the general counsel relationship because we want to just make sure that every single step of the way, we have all of our ducks in a row. So the relationships aren't the same between companies. It really depends on what comes along as you grow and scale the business.
That makes sense. Everybody is so different. Like, we're the same in many ways. Like I always say, if you're the king or queen of England and you drop an apple, it's going to fall at the same speed as anybody else. We all have things that are special about us, but we're all human. Our businesses all have to work within the physical world. Gravity is gravity for everyone. Profitability is profitability for everyone. It doesn't matter what business you're in, but there are so many different models and structures within the ABA industry, hopefully, when there actually is structure. So I wanted to zoom in a little bit on the risk tiers. We often deal with clients who get into a contract or they've scaled into a position that's very difficult for them to back out of. They have a model, they've applied it. Maybe they have a lot of part-time RBTs that are doing in-home services because the RBTs are working so few hours. They can't afford to invest monthly fixed cost into those employees because they don't have enough hourly profits coming back from those employees to pay for things like security or having company owned devices and things like that. What we do in those situations, and most of the customers that we're dealing with are not huge companies with unlimited funds, right? In those situations, number one, we make sure that the business owner is informed. At least you need to know what's going on, and you need to know what you can do now to start moving in the right direction. Check those little boxes you can take care of right away. Your software that you do have, you can sit down and write a password policy on Microsoft Word, print it out, have all of your employees sign it, and put it in the file cabinet. Boom, you've got a policy, and now you can go through and make sure that all of your systems are enforcing that policy, right? This is something that a business owner can do themselves for free. But when it comes to firewalls and email security and data retention, it starts to get into tools that cost money. So our approach is to lay out their plan of action and milestones for compliance. And when you pull up the tiers, I was looking at those and I was thinking, how does it really apply? What level of subjectivity or objectivity in enforcement decisions on those tiers? How are those decisions come to? So if there's a breach and HHS shows up, or there's an audit, even the Medicaid Fraud Control Unit, they can do a records review and that turns into an audit because you don't have compliance standards in place. And then when that becomes an audit, now you've got the same situation and you're getting fined and penalties. So when an auditor comes in, what can a company do with regards to having a plan of action to protect themselves from being in a higher tier?
Yeah. Yeah. So a lot of it is going to depend on unfortunately, it is a lot of subjectivity. There's no real standard of saying if you do X, Y, this is how they're going to apply it. So the best thing that you could be doing is showing them internally, here is the last time we did our risk assessment. Here are our policies and procedures that we had in place. And again, that's the way I see it, is when you can give them something that kind of shows that you've been trying to comply at the very least, you take the tier 4 off the table. I'm not really aware of a lot of tier 4 violations that have happened with companies are really striving to comply and a breach happens. These are really, it's the tier 4 is really when companies know that something is going on and they just continue to ignore it. So we start with the documentation so that we can at least hope that at worst we're around the tier 2 area, because then at least you can say, okay, you weren't just it was not a dereliction of duty. You actually have been trying to comply. So that's where I started documentation.
Yeah. And that's what risk management's all about. And you need to have a risk management system in your company. And I always talk about building the structure, dividing your company up into these functional areas. And there's things that you must have that are operationally required. Operations, finance, clinical, those types of things. And then you have these meta systems, the infrastructure that holds up the other systems like technology, right? Your practice management systems, it's going to overlap into finance, it's going to overlap into your clinical and your operations. And then you have the overhang of your risk management, compliance, your governance, and being blind to that is a danger. And I think that the business owner doesn't realize the power that they really do have to just look at these things and pay attention to them and manage risk in a way where they're not going to have the massive exposure of tier 4. Even if they do have tier 2 exposure, when that audit happens, we can show that we're working on it, because we have a lot of companies that will look at it, they'll be overwhelmed and they'll say, this is too much. I'm just going to pray this doesn't happen to me. And then you get the call 6 months or a year later and it's okay, this thing happened, I'm in trouble. There is a lot that you can do that doesn't cost you anything but time and a little bit of educating yourself and making sure that this is not a blind spot for you.
Yeah, absolutely. And I mentioned it before, just because there is a violation doesn't mean that you're automatically going to get fined. The entity that it really imposes the penalties is the Office of Civil Rights, the OCR. And they sometimes, depending on the nature of the breach, will just offer guidance. It will say, here's what you could have done. What you don't want is you don't want to actually suffer a breach. And then you think, I really don't want to get in trouble here, so I'm just not going to report it. Because then if something happens and then you do end up getting reported by someone else, that's where you're really going to start to get into the other tiers. So it really doesn't take a lot to build up just some documents like you just said, so that you're just mitigating that risk. And a point that I did want to bring up that I forgot to bring up in the presentation is, as a business owner, when you have these contracts, especially the BAAs, there's ways that you can protect yourself beyond just having the check the box obligation of having a BAA, you have the flexibility of including information in your BAA. So for example, if I'm hiring an RBT and I want to hire them as a 1099 and they're remote, I can actually include in my BAA provisions that will basically articulate that you're going to adhere to our policies, our procedures, and you're going to keep PHI safe. If you don't, and we get punished as a business, we have legal rights against you. You have to maybe reimburse us. There's different ways that you can get protected, even though you're still going to be subjected to potential penalties if there is issue that's related to what they're doing.
Yeah, and when you look at the terms and conditions for all of the SaaS applications, and if you guys have a practice management system, an EHR, copy the terms and conditions, drop it into ChatGPT, and start asking questions. That's the easiest way to do it because they're so long. It's not a way that you want to spend your Saturday reading the terms and conditions of your SaaS providers, but they all have a couple things in common. And this is not because they're evil. It's just because the nature of them managing their risk as a software provider. None of them are responsible for your data. None of them are responsible for your compliance. The three magic words came out of Sam's mouth during his talk today that comes up in all of our live streams, almost completely across the board, which is you are responsible. So you don't want this to be a blind spot. You at least want to know what's going on in this area. When I talk to the head of software development for CentralReach, and I say, what are we doing for clients to make it easy for them to access their data and so that they can have redundancy, right? This is a HIPAA requirement. You must have redundancy of your data. It cannot all be in one place. And he says, we got all that built in. That's not how the regulations actually read. You're the business owner. You have your client's information. You can't depend on these SaaS providers to keep your data safe. And that goes for Microsoft, for Google, for any of your SaaS providers. And I'm cracking on CentralReach because I know them. Like I'm talking to them. But all of the SaaS providers are the same. They are specifically stating in your terms and conditions that they are not responsible. You are responsible. And I don't know if you saw this, Sam, but did you see that the Office of Inspector General is actually cracking down on the Office of Civil Rights because they were only evaluating 8 of the 180 HIPAA requirements when they were doing their audits?
Oh, no, I didn't hear that. I didn't hear that.
Okay, so the U.S. Office of Inspector General is going after the Office of Civil Rights for not being hard enough on you, the covered entity. So they're doing some changes in their technical standards, and they're going to start turning up the heat on this. And this comes from the perspective of regulators looking at the situation, seeing the identity theft problem and the cyber crime problem that we have worldwide, and where can we protect this? Like, how can we stop grandma's social security check from getting stolen? How can we stop Timmy's identity from being stolen when he's 7 years old? And by the time he turns 18, goes to apply for a credit card, he's got 2 mortgages he has no idea about. Where do we go to stop the leak? And the only place the regulators have to go are small businesses, because we are the main raw material, the resource for these bad guys to get data from, because they know that we're holding the data. That's where this stuff is coming from. It's not from a down with small business kind of a thing, but it is a problem that has to be addressed some way. And really the only way, this is the American way, right? The only way to solve a problem usually ends up being a small business somewhere or an industry of small businesses. So what do you see in the ABA industry as far as business owners being able to take action on simple things themselves and start to build what they need within their business if they don't have a budget to pay someone else to do it? If they're short on time and money, what can they do to sit down and really start developing out their policies? What kind of resources do you recommend as far as them starting to take this on themselves and start managing their risk?
Yeah, so I think I would look to the results of your risk assessment to see where your holes are. And I like AI in the sense of when you're asking it the right questions and really helping you, that might be a very good basic first step. If you just don't have any money, you can really just thinking about, you're not putting in any, don't really put any particulars about your business at all, but like you're really asking it, I use Google, I use this, I use that. What policies can I implement in my practice? And that might be a really good first start. you want to get professionals involved when you start to really get some traction with your business. That's where I see companies start to really move. That's the companies that really start to hire us because they're starting to understand and they're realizing that, oh, I'm making money now. And then now I'm afraid to lose it. So there are some of them that just take the risk and they just don't do anything. But there's ways that you can just really just start yourself. I think AI could be a really good first step.
Just as a shameless plug, we have our Odyssey platform and our blueprint series of courses where in foundation, we help you set up your AI. And yesterday, the question came up about ethics. Today, we have AI being used to meet HIPAA compliance. The first two things that we add to the executive assistant GPT knowledge base when we're building that out in the foundation course is BACB code of ethics, HIPAA simplification. Drop that into your AI, and then we start building from there and start developing out your policies. This is something that you can do for the founders link that I dropped in there. It's still only $97. So if you can jump on there, get through the foundation course, start building out your structure, we get into all these meta systems and stuff, and then start educating your executive assistant GPT to start building these things for you and doing it safely, and at least have something. It's much easier to deal with an audit. It's much easier to deal with a problem or a breach. A bad plan is better than no plan in most cases. I have seen some bad plans, but at least you have something, right? Definitely encourage everybody to use these resources. We're going to put all this stuff in the comments and in the description of this video. So roll through there, look at these resources, use them, reach out to Sam, definitely engage with your compliance as a business owner, because this is a huge area of risk and there is a lot that you can do yourself to start managing that risk and make sure you're lowering your risk from tier 4 down to that tier 2 and staying in that zone. And Sam is here to help. Our team is here to help. And once again, Sam, thank you so much for joining us today.
No, it's my pleasure. I really appreciate you, Derek. Yeah, this is great.
Awesome. Thank you, everybody. If you have anything that you need, just go through the comments. We'll drop some more resources in there, and we'll see you guys in the next one. Thank you, Sam.
All right, my pleasure. Thank you, everyone, for joining.
You're already doing the work, investing your time, your energy, and your vision. So let's make it count. Build something that works without breaking you. The EBCBA Blueprint is the way. Get started for free with our foundation course.